afternoon, and thank you for joining us for our special webinar presentation with guest speaker Dykes Boddiford. In just a few minutes, Dykes will be educating us on different types of trusts and strategies for investing and using trusts in preview of his upcoming class. My name is Larissa Green with Advanta IRA, and I'm going to take just a few minutes to tell you a little bit about Advanta, and then we'll go forward and I'll let Dykes take over, and he'll be talking about different types of trusts. Now, as we go through the webinar, Dykes is going to share a lot of information, and we will try to take a few questions, maybe throughout the webinar and a couple at the end, time permitting. Again, my name is Larissa Green with Advanta IRA. I'm the Director of Education here, and I've been with Advanta for 6 years. Advanta does not give any legal, tax, or investment advice, but if you have questions and you're not sure if it's something we could answer, go ahead and let us know anyway. And if it's not something we can help you with, we can definitely put you in touch with people who can help you with those questions. Advanta IRA is a self-directed IRA administrator, and we can also help you with self-directed HSAs and ESAs. We have 2 offices, one in Largo, Florida, which is where I'm based out of in the Tampa Bay area, and also an office in Atlanta, Georgia. But we do service clients nationwide and even worldwide, and their investments are all over the world. So we can really help you with self-directed investments that you choose and you see fit for your retirement accounts. What we pride ourselves on is our customer service and the fact that we provide each of our clients with a dedicated account manager to assist you, so you know exactly who you're reaching out to when you have questions on investing and your account specifically. So anything from contribution limits all the way up to guidance on making those investments that you choose for your retirement account. We have an amazing education center here at Advanta, anywhere from our webinars like we're presenting today all the way to live presentations at our local offices and in those areas, as well as our on-demand center where you can find our webinars and our YouTube channel. We do archive everything, and so if there's a webinar that you've seen on our listed events that you've missed and you want to check out Advanta IRA on YouTube, and you'll be able to find all of those webinars there. We also have a blog that we update regularly, and we're always looking at topics that are the latest on investing and retirement accounts, and so it's always really good information if you're looking for ongoing education. A self-directed IRA is very simply something that the IRA holder chooses the investment. It's a vehicle where they can choose the investment. They are not limited to things that are publicly traded, and so whether that be something like real estate or precious metals, a self-directed IRA administrator can help you with those investments. And actually, anything that ends in IRA can be self-directed, and so self-direction really describes the investment more than the account. If you have a retirement plan and you would like to self-direct it, it's something that you can do with Advanta. Anything from a traditional IRA and a Roth IRA, of course, the most common IRAs that we see, all the way through any type of employer's plan, health savings accounts, and education savings accounts as well. We really see all types of investments, and really the sky is the limit. There are some rules involved, and we're not going to talk about them today in this webinar, but if you're interested in learning more specifically about self-directed IRAs, join us for another one of our webinars where we're talking about the rules and types of investments. But just to give you a quick idea of real estate investments we see our clients investing in, it can be rental property, really of any kind. So if you like residential property or commercial, you prefer condos or duplexes, you like single family homes, all of those are investments that you can make with your self-directed IRA. You can do rehabs and flips. There's no certain amount of time that you have to hold an investment in a self-directed IRA, so those are permitted. Notes and mortgages, and very common in a self-directed IRA. The great thing about notes and mortgages is you get to determine the rate at which your IRA is going to earn, and so if you want to earn 10%, then you can lend out at 10%. You determine how long you're going to hold that note and if there are any points. Joint ventures, something very common we see, option contracts, tax liens, and then of course checkbook control structures like LLCs and trusts, which we'll be talking about today. There are two different types of trusts that we see with self-directed IRAs, land trusts and personal property trusts. What is unique or special about using trusts with self-directed IRAs is the IRA is actually both the grantor and the beneficiary in that case. So when you put your trust together, that is the specific information that you will need in order to do that with a self-directed IRA. And then the IRA account holder will appoint a third-party trustee. So that's very important. It has to be a non-disqualified third party as trustee for the trust of the IRA. That trustee will then open up a bank account and make investments as directed by the IRA account holder. If you have any questions on that, please feel free to reach out to me. And with that, I'm going to introduce Dykes. Dykes Bodiford is a investor out of Atlanta, Georgia. And give me just a second, Dykes, and I'll get you. Dykes, are you there? Can you hear me okay?
I'm here.
Okay.
Can you hear me okay?
How are you doing today? Yep, I can hear you just fine.
Great. I'm doing fine. And,
okay.
Larissa, I have to compliment you. That was one of the better explanations I have heard on the use of trust within the IRA. I think you hit the nail on the head. Are you still there?
Yeah, thank you very much. I appreciate that.
I just wanted to make sure I hadn't lost you.
Yep. Right. Thank you.
Well, I'll take it from here then, Larissa. Thank you very much. Today we're going to talk about some trust concepts, and because of our limited amount of time, we're going to emphasize land trust and personal property trust. Though you should be aware there's a lot of other types of trust that can be used by real estate investors as well as investors in other areas of investment. So let's talk about trust. What is a trust, and how does it make a difference? And I got to figure out how to. There we go. What is a land trust? Well, understand that in most states, most of the 50 states we have in the United States, trusts are not defined as a state statutory entity. It is rather a contract, an agreement between the trustee and the beneficiary that separates ownership rights and property. If we look at the ownership rights and property as a bundle of rights, this separates the bundle into two separate bundles. So what are property rights? Well, there's quite a few of them, many more than are on this slide, but just some of the ones you would recognize would be the right to occupy or to use the property, to improve the property, to grant easements, to borrow money and secure the loan with a mortgage against the property, a lien against the property, can farm, mine, drill on the property, restrict the use of it, have covenants on the property, subdivide the property, exclude others, and right on down the line. There's many, many of these. And if you were studying a property in a property rights class, you would spend several weeks on the different rights and what they mean to real property. Well, with the land trust, there are two specific rights that have been transferred by agreement to the trustee of the trust, and that is the legal title and equitable title. Legal title is the right to be known to the public as the owner of a property, whereas equitable title is the right to transfer property. Many trusts, such as a living trust, only transfer legal title to assets, whether it be real property or personal property. So the land trust is different from the living trust in that important way, something you should be aware of. Now, the beneficiary only has control of those two rights. Now, they may have control of many of the other rights in property, but they only have control of those two rights through a power of direction over the trustee themselves. So the beneficiary cannot exercise legal title or equitable title. They must direct the trustee to deal with those. So let's look at some of the benefits of a land trust, and there are many here. One of the primary reasons we want to use a land trust is the anonymity that we can gain. The beneficial interest can be easily transferred from one person to another, which is another benefit. The land trust prevents petition suits, which is the right for one owner of a property where there are several owners to sue the other owners to either petition the property, separate it into separate parcels, or to sell the property and split the proceeds among the owners. There are no rights of petition within the land trust, which keeps that legal issue from ever coming up. Judgments against individual beneficiaries don't attach to the property itself. The land trust can avoid probate if successor or contingent beneficiaries are named within the trust. As I said before, this is not a statutory entity, so there's no state filing fees and no registered agent required, and no annual report that has to be filed with the state. And of course, no annual registration fee that has to be paid to the state as well. There's easier management where there are multiple beneficiaries, and we see this quite often where a family might be investing money from different persons within the family, but the beneficiaries are not experienced in the real estate, so only the person that is appointed as trustee can handle the property itself, and so therefore the beneficiaries have someone representing them. It can provide estate planning if estate planning clauses are added to the trust. It can help avoid EPA liabilities from simply being in the chain of title. I'm not talking about if you caused the EPA liability. I'm talking about if you bought a property, there was an EPA problem on the property. If you bought it into a trust, you personally would not be within the chain of title, so would not be personally liable just simply by being an owner. There's no tax return required because these are considered grantor-type trusts. And under the IRS code, grantor-type trusts do not file a separate tax return. Rather, the person that is the grantor is the one that files the return, which is most often also the beneficiary. Again, legal and equitable title are vested with the trustee. That's the benefit. The beneficial interest is considered personal property, not real property. Now, that's a benefit that we'll see a little later in this presentation when we talk about owning properties in multiple states. Trustee is not personally liable. The reason the trustee is not personally liable is because they are not the ones that have control over the use of the property or over the maintenance of the property. The beneficiaries are the ones that retain those rights, and therefore they are the ones that potentially have liability if there's an issue on the property. There's no ancillary probate for property in other states. We'll talk about that a little bit more. It assists in dealing with the due on sale clause if you're buying a property subject to an existing mortgage that's on the property. It obviously can provide privacy for transactions that are done in the land trust. And it can provide for non-judicial repossession where the beneficial interests are sold on installment rather than the real estate itself. Now, that's a more advanced structure, and it's something I would caution you to get a good education on before you try to put that into effect. Also, attorneys are generally unknowledgeable of trust, and since they don't understand them, and they really don't want to spend the time to really study trust law and trust cases in order to get up to speed. So just by virtue of the fact that they are uneducated on trust means that often they are reluctant to ever go after trust. And, of course, they can provide non-recourse financing in cases where the beneficiaries don't sign personally. Now, as I said, the trust is not a state-mandated entity, and therefore the state does not give it a liability shield such as it gives to corporations and LLCs. But the land trust does provide some practical asset protection. Obviously, the anonymity, just by keeping a low profile, flying under the radar, and not being named on public records, can provide some anonymity so that the public can't see who is actually owns the benefits of the property. It provides a hurdle for someone that might be suing you. Now, I will caution you that all the things we're talking about with both the land trust and personal property trust can be used to scam people. And that's not the intent here. The intent here is to protect yourself against frivolous lawsuits. So if you really have harmed someone in not maintaining a property, or it's some reason that you should share that liability, step up to the plate. Make sure your insurance covers the problem, or you personally take care of the problem. What we're trying to prevent is the frivolous lawsuits that we hear about so often in today's environment. The attorneys we talked about don't understand the trust and therefore typically will not attack trust. So if there's insurance to be had, that's as far as they typically will go. And when there's not insurance or when there's a suit that insurance is not covering, the trust, because the attorneys don't want to go after the trust, don't understand how to attack a trust, they will encourage their clients to settle for often pennies on the dollar in order to get past the suit and move on to other activities that might be more lucrative. With the land trust, with the personal property trust, all the duties, responsibilities, powers, and benefits are all relate to personal property, and there's a good bit of difference between the two. So you can't use the same document for both. So the personal property trust, again, is an agreement between the trustee and beneficiary that separates the right of ownership in personal property. Some of the uses for personal property trust is for vehicles, cars, trucks, boats, and so forth, tools and equipment, bank and brokerage accounts. I will caution you right here that if it's a bank or brokerage account and you're setting one up, don't go in and ask them for a trust account. You're putting yourself in for a lot of headaches and a lot of paperwork. You want a regular business account, but it happens to be a trust that owns the account, it's not considered a trust account. You can use personal property trust for holding options. As a lender, I often use personal property trust, which is also referred to as a paper trust, as a lender on hard money loans. You can have IRA-owned asset trust where you have one or multiple IRAs on a trust that may loan money out. It may own options, or one of the things we've used these trusts for is to own tax deeds and tax certificates in multiple states. Personal property trust can be used for estate planning just like land trust can be used. Again, it has to do with what the property owned by the trust is as to what you want to happen if something happens to you. It can be used as the owner of the stock or the interest in LLCs or corporations. It might be something that some of you will want to consider. Here's an example of a personal property. Yes.
If we could interrupt just a second, we had another question pop up here. What about refinancing a property in a land trust? Does that complicate the process?
Yes, it can. Now, I can tell you that we spend a good bit of time in the weekend class, which I'll talk about in a minute, talking about financing and refinancing. If you have to go to a regular institutional lender, then they're going to want you to buy the property or refinance the property in your own name. So you're going to have to put it in your name, get the financing, but once you put the financing on it, you can then put it in the trust. Now, the negative is the fact that you're now in the chain of title showing that you actually own the property. So if you refinance, you're going to probably have to put it in your name. Now, if you deal with individual lenders, private lenders, a lot of times they'll allow you to finance or refinance in the trust name. Now, I do this a lot with loans that I make. I do have the person that is the beneficiary sign personally, but that's on the note, which is a private document. It's not on file at the courthouse. And, of course, the deed to secure debt, which is our deed of trust, shows just the trustee and the trust is the owner of the property. So in the diagram I'm showing here, you see a personal property trust where you might have began ownership of a boat in your name, and you transfer it to a personal property trust, obviously with the trustee, but now in this case you're the beneficiary. Here's the same structure with a vehicle, personal property trust with a trustee, and in this case I'm showing a beneficiary as an LLC in order to provide that liability shield that if for some reason there is a liability that comes with the vehicle from you hitting the attorney in the crosswalk, then he decides to pierce the trust because it's not a statutory entity. He hits an entity that is statutory, the LLC, with a liability shield that further protects you.
And so we had a question pop up on that one. So the insurance policy, is that in the name of the beneficiary?
All right, good question. This is also true for the land trust. The insurance should always be in your name because you're going to be the beneficiary, because you have the responsibility for maintaining the property and the upkeep on the property. And then the trust should be named as an also insured as their interest may appear, a TEMA, as their interest may appear. And this will allow you to get the multi-policy discounts because you're going to have several different land trusts holding the different properties. And you'll be able to get insurance, umbrella insurance on the liability portion of the policy because you're being covered in that respect. So think about the insurance policy as covering both the property itself, vandalism, loss due to windstorms or lightning or fire or whatever, and the liability coverage that you as the beneficiary would want to have in case somebody wants to come after you personally for whatever reason.
Okay, thank you for that, Dykes.
You're welcome. All right, and here is a example of a bank or brokerage account held in the name of the trustee as trustee of the personal property trust, and you as the beneficiary. Again, remember that account, bank or brokerage, is not a trust account. It's owned by a trust, but is a regular business or personal institutional account. Now, here's a good friend of mine who used to be a private investigator. He worked for one of the larger insurance companies in the United States. He was tasked with doing background research on a potential person that had potential liability on a case. So he investigated and he found several properties, quite a few properties, and bank accounts and trust names that were associated with the subject. He had obvious proof that these accounts were held by that person. But even then, the attorneys of this large insurance company did not want to pursue them because these were trusts, and they did not feel comfortable trying to attack trust in getting to these bank accounts and properties. I thought that was illustrative of what attorneys think out there. And lastly, here's an example of the ownership in an LLC or corporation, the interest in stock being held by a personal property trust, of course, with a trustee, as opposed to that property being held in individual names. Okay. Now, let me just show you a class that I've got coming up here next month that I think some of you may be interested in, and then we'll take a few questions. This is called the Trust Concepts and Strategies class, and it's being sponsored by the Upstate CREA, which is a real estate group in Greenville, South Carolina. They're actually the ones doing the sign-ups, but you can find a link to their website from my website being assets101.com. The class is on August 26th and 27th, a Saturday and Sunday, and we will cover all of these that we've covered today and a lot more in detail. And we've got a detailed manual that goes along with it. By the way, the manual is not a workbook. The manual is a text manual, so you have something to put on the shelf when you get through with the class that you can pull down and refer to. It describes all the concepts in great detail and step-by-step how to deal with different issues. Also, a disc comes with the class of all the forms that you're going to need. And here's some of the things that we'll be covering. The land trust and personal property trust, the relationship of all the players, how to pick trustees, a strategy called stacking trust will be discussed, where you can have multiple trusts owning multiple trusts, how to maintain privacy, using co-trustees and why that might be beneficial for you. We'll talk about title issues and who really holds the title and why, which I think the why is really important because a lot of times attorneys don't understand these things and you need to understand in order to explain to them. You'll be surprised how much you'll find attorneys really don't understand once you have an advantage in knowledge in one area. Trustees and their fiduciary responsibilities, how to deed properties into trust. Most people that talk about land trusts only have one way to deed into land trust. We'll talk about 3 different approaches because there are arguments that an attorney for the other party might argue about how you can put deeds into trust. We'll talk about that and how you can solve that issue. Contingent beneficiaries, successor beneficiaries, estate planning, how to change trustees. A lot of people don't realize that you can change trustees, but it's got to be done properly. You can't just wave your hands. You need to actually have some paperwork trail for that. Transferring property properly, and then how to deal with income taxes. I said you don't have a taxation on the trust individually, but we'll talk about what if you want to file a separate income tax return and what the benefits and negatives will be for that. How to pick a trustee. And how about when trusts do owe taxes, is the complex and simple trust concepts. Extending the trust, merger of title, merger of interest issues, how to amend the trust, avoiding probate, 1031 exchanges, the statute of uses and what that means to you, liability issues, how to avoid litigation, dealing with multiple owners, what different types of beneficiaries can you have, the importance of beneficiary agreements, again, grantor, non-grantor trust, what that means, proper use of directors, which is another entity, or another capacity that someone could hold within a trust to direct the trustee for the benefit of the beneficiaries. Funding the land trust properly, what can you use for funding? How to avoid revealing the trust documents themselves. That's to the attorneys or to the public. Land trust and the deal on sale clause, what the true story is on that. Financing a property in the land trust and avoiding probate. We'll talk about variations of the trust and different clauses that can be used to actually give more power to the trust. And then we're going to cover several transactions involving land trust. And here's just a few of them. All cash purchases, the purchase with new financing where the property will be in your name. Purchase with new finance where the property can go directly into the land trust. Subject to purchases, buying at foreclosure auction, using a land contract, buying using a lease option or lease purchase. The day-to-day operations of the land trust. Refinancing land trust property. Transferring property into a land trust. Transferring beneficial interest, selling property that is in the land trust. Another one that a lot of people miss is how to continue the trust past the initial 20 years of the trust, or can you set it up on some other term, and we'll talk about that. And then, of course, closing the trust, terminating the trust. Once you have used the trust, how do you terminate it so that nothing can happen in the future? So that's just kind of an overview of the things we'll be talking about August 26th and 27th in Greenville, South Carolina. And I would love to see a lot of you there. I think this is going to be an interesting session. Actually, John Heyer is going to attend the class as an attendee this year, which I think is always great to have an attorney sitting in class. And we usually have 1 or 2 attorneys in these classes anyway. By the way, this is the only time that we'll be teaching this class this year. So look at this as an opportunity to learn more about trusts. Larissa, do we have some other questions we might be?
We do, actually. We had a few people ask more questions about how you handle the insurance when you're doing the trust and LLC strategy. Could you go back over that briefly? So I think we'll answer those questions if we just review it.
When you get by the way, every insurance company is a private entity, so you need to have a very heart-to-heart discussion with your insurance agent. You're not trying to hide anything from them. Explain to them what you're trying to accomplish and tell them to talk to their underwriter if they don't have an immediate answer to your questions. But generally, here's how I've been doing it over the years with several different companies. Have yourself as beneficiary named as the policyholder, but then have the trust named as also insured. Now, if you have an LLC in between that holds the beneficial interest in the trust and you own the interest in the LLC, you'll want to have the LLC named as an also insured as well. And you can have 3 or 4 different also insured. Now, that also insured should also have a tagline on it that says, as their interest may appear, A-T-I-M-A, ATIMA. And by having yourself as policyholder, then you can get multiple policy discounts if you have several properties, each one held in a different land trust. And remember, you want coverage for the liability issue. You want the trust to have coverage for damage and vandalism that might occur on the property. That answered, Larissa?
I believe it did. And then I also had another question pop up, and the attendee is asking what net worth would determine a need to create a trust, and I feel like that could be very detailed, but maybe just broadly answering.
Well, it's a pretty easy answer. It's when you feel paranoid enough that you want to have the trust. When I started out, when you start with your first property, go ahead and put it in your own name. You probably don't have a whole lot to lose, so you got one of the best asset protection mechanisms out there. But as you start adding to your net worth and adding properties, educate yourself on the trust. And by the way, if you're just starting out, it's a good time to learn about trust. Even if you don't put your first property in the trust, you will have the education then when you feel more comfortable with it to start putting properties as you buy them directly into the land trust. Remember, the trust won't cost you anything with state registration or annual fees or annual reporting. It's just gaining the knowledge to set up the trust and how to deal with the trust.
Okay, great. Thank you. I think that's it. If anybody has any last-minute questions, go ahead and get them in there. And let's see, I had another one pop up here. Regarding liability insurance for the beneficial interest holder on several properties, that would be an individual umbrella policies rather than a form of personal or, sorry, I jumped around here.
All right,
umbrella policies.
I understand the question. Okay. Yes, the liability would be just the liability portion of the individual dwelling policy, or in the case of a flipper property, it might be builder's risk insurance. And the umbrella would take that liability level, which is typically $300,000 to $400,000, and carry it up to $1 million, $1.5 million, $2 million. That is another reason why I suggest having the dwelling policy in your own personal name so that you can get that umbrella policy to then extend the liability. And again, really get your insurance agent. Actually, it's best to take them out to lunch so that you've got them committed to listening to you and not rushing through a discussion, and try to tell them exactly what you're thinking and why you want to try to accomplish this, because you don't want the insurance company to ever think you're trying to scam anybody. And you want to make sure that your policies are set up the way the insurance company recognizes ownership properly.
And I actually had a question on the class. What is the cost to attend the class?
There's some different tiers, but if you're a member of any RIA, not just the South Carolina RIA, but any RIA, the individual price, I believe, is $495. You can find that on the website. So it's very reasonable. That includes your class manual and the electronic version of the forms.
Okay, great. I think that we're going to go ahead and conclude. I see some other questions pop up there. Feel free to reach out to my office and we will get your questions answered. And I just want to thank Dykes for joining us today. I really appreciate it. That was a lot of really great information. Make sure you check out the information on the class. And with that, I thank you very much, Dykes.
Thank you very much, Larissa, for having me.
Have a good afternoon, and thank you, everybody, for joining us.